Okay. On behalf of Baker McKenzie and the IMT Group, welcome and thank you for joining today's webinar, Asia Pacific IMT Webinar Series, Import and Export Regulatory Updates and Recent Case Developments in Thailand. My name is Yaiko Hodaka, and I'm the co-chair of the Asia Pacific Industrials, Manufacturing and Transportation Industry Group of Baker McKenzie, based in Tokyo. As you notice, customs issues are something very important, but at the same time, sometimes unpredictable, especially in Southeast Asia. Not a few companies with a big presence in this region get into trouble with customs authorities because they are not well prepared for customs audit, or they lack good understanding of rules of origination of goods, classification, customs validation, and so on. Further, the number of goods subject to economic security has been increasing and becomes more complicated due to the current unstable international situation. So we decided to host a series of webinars focusing on customs audit and disputes in Asia Pacific, covering major jurisdictions in the region. Today's session will focus on Thailand. I'm pleased to be joined by my colleagues Panya and Kelati from our Bangkok office. Panya is a partner at our Bangkok office's tax practice group, who is also active in the International Commercial and Trade Practice Group, and in particular, practices in the customs and supply chain areas. Panya is recognized for advising clients on highly complex tax structures, offshore investment, international tax planning, tax disputes, and tax litigation. Kelati is an associate at our Bangkok office's tax and international commercial and trade practice groups. He specializes in indirect taxes, including customs laws, audits, and disputes. He previously practiced in-house at an automotive company in general corporate matters, labor laws, intellectual property laws, and customs law. And now I will hand it over to Panya, who will kick us off with today's presentation.
Thank you, Yaiko, and welcome everyone to the webinar today. So we will walk through the agenda. So we do emphasize on the import-export regulatory update for over the year during the pandemic situation. Also, we bring the recent cases and developments in the area just to give you the heads up what is really going on in Thailand. And then we have some case studies. At the end, we will have Q&A session. Please feel free to give us the questions in the Q&A chat box so that we can respond at the end. If we do not have opportunity to do so, we will respond back to you individually after the webinar today. We will begin our discussion with the import and export regulatory updates and the recent case. Firstly, I would like to give you the overview of the environments and the situations in Thailand. As you know, we have COVID situation for 2 years. However, Thai government as well as the Customs Department has been very proactive about trying to develop the systems and the countries. So now you have seen or have heard many of the initiatives launched by the governments. I will recap some of the things that are very interesting. First thing first, for the EV projects, this is very big project in Thailand. The government tried to change the vehicles in Thailand up to 30% of all vehicles to be EV car within 2030. So it's going to be 8 years from now. Just this Tuesday, the cabinet has approved the new excise tax scheme that will, decrease the duty rate and excise tax for the EV vehicles, including not only the sedan vehicles, but this time include the pickup trucks as well as motorcycles. The users will also get some subsidies from the excise department as well. The gas station will be turned to be electric charger very, very soon. So this is very big initiative. Then all the supply chains related to the vehicle manufacturing will be promoted. So this is the very big initiative. Also, the government also focus on the tech companies and technical business. For example, they would like to promote Thailand to be the storage hub for cloud services. So that's another initiative that Thailand is moving towards too. In addition to the EV and high technology industries, Thailand also continue to promote general business. For example, BOI has continuously launched the promotions for many of the core business to be invested in Thailand, but they will come up with the high technology requirements. So if we have high technologies or R&D attached to the business, then tend to have more BOI promotions or longer period of the promotions. Last but not least, they also propose to decrease the duty rate for luxury products and fashionable products like the cosmetics, clothes, cigarettes, for example, so that they can build Thailand as the tourist hub as the next step. So stay tuned on that, because right now the duty rate for those kind of luxury products are very high, could be 20% or more. So if they can reduce this, Thailand will become even more attractive for the tourists in the future. So this is the overall situation of the Thai government. Now I will turn to Kun Kirati to explain about the updates on the recent FTAs with many countries, as well as the export control law, which has a lot of developments in the area. So Kun Kirati.
Thank you, Kun Panya. So before moving on to the FTA parts, we would like to provide you the overview of the custom regulation and the notification of the Ministry of Finance development in Thailand as well. Last year, there are actually 38 notification of the Ministry of Finance and more than 240 notification of the Custom Department issued to cover the regulations and practice of the Custom Department. And up to date, for this year, there are now 24 notification of the Custom Department issued to cover the main regulation of the Custom Department. And more importantly, it relates to the free zone operator, particularly the free zone operators of commercial activities. And please be updated on that part. And for today, we would like to update you about the FTA updates regarding the national regulations in relation to the FTAs in Thailand during last year until now. So the first one that you may be aware of is the RCEP. RCEP has been fully enforced from the 1st of January this year, and the Thai Custom Department also issued another regulation to cover on that part. Then we have the ASEAN-China FTA regulation that relates to the change from HS series of 2012 to the series of 2017. And then the custom regulation also provided specific provisions regarding the Form E from China that can be accepted when it is issued by the China Council for the Promotion of International Trade as well. And another update is regarding the ASEAN-Hong Kong FTA. As you may be aware of, that Thai Custom Department used to interpret that if there is no clear guideline or clear rule on the third-party invoicing regulations, that such third-party invoicing can be more than one party, then the Custom Department will strictly and conservatively interpret that there must be only 3 parties involved in the transaction. According to that interpretation, there was a change and revision of the custom regulation or the notification of the internal division of the Custom Department to interpret that the third-party invoicing can involve more than 3 parties. And then it reflects as well to the ASEAN-Hong Kong FTA that according to the previous meeting of the ASEAN-Hong Kong in last September, there was a flexibility to use the last third-party sales invoice for claiming tariff incentives in Thailand as well under the third-party invoicing scheme from ASEAN Hong Kong FTA. And next one is the Thailand-Japan FTA, or you may be known as JTEPA. So there is a change in product-specific rules from HS Code 2002 version to the last update version of HS Code 2017. And also the minor change of the JTEPA format in regarding to the change of the HS Code, and as well as the JTEPA format in an electric format as well. But due to the time constraint, the IT system is not implemented fully. Then the Thai custom also allow that we can actually use the PDF form of the JTEPA form through the designated IT platform as an interim measure as well. And also that there are actually revised operation procedures to provide additional system for government officials to examine the authenticity of the form FTA of the JTEPA as well. And the next one is the Thailand and Chile FTA. This relates to the replacement of new form TC or Thailand-Chile template to be used from 1st of September last year. And the next topic is about the export control updates. So as you may know that the Trade Control on Weapons of Mass Destruction Related Item Act has been actually enforced from 1st of January 2020. However, due to the absence of the important regulations, then there is no full implementation from that day. Last year, there were actually 3 notifications issued from the Ministry of Commerce and also the Department of Foreign Trade in order to regulate on the products and also the measures that will control the weapon of mass destruction, or WMD, in this scenario. So the first one is the notification of the Ministry of Commerce on measures to control products related to proliferation of the WMDs and measure on goods with suspicious grounds that the end use or end users is related to proliferation of the WMD. And the second one is the notification of the Department of Foreign Trade on certification criteria of Internal Compliance Program, or ICP. And the third one is the notification of the Department of Foreign Trade prescribing forms for notifying the risks of proliferation of the WMDs. So move to the first MOC notification on the measure to control products. Or this regulation is effective from 26th of December last year and relates to the catch-all control, which is the CAC, and also prescribe the list of the product that will be under the control of the WMD Control Act. So there are actually 2 lists of the control goods. List 1 is the goods that are considered as DUI, or based on the EU dual-use item list as revised of the list of 2019. And list 2 is the goods that can be regarded as the dual-use item based on the SS code or the custom tariff codes. Then the activities that the government would like to control include the exportation, the re-exportation, transshipment, transit, and the transfer of technology and software, which pose a risk of proliferation of the WMD, or there is a suspicious ground that the end use or the end users is related to proliferation of WMD. So actually, in this regulation, it is obliged to notify the Director General of the DFT to assess the risks and impose export measures. So it means that Thailand is the country that would like to create the obligation to the authority, which is the Department of Foreign Trade or DFT, to actually assess whether there is a risk that the product will be fall under the list 1 or list 2 as the DUI item, or the products will be used by the prohibited users or not. And next notification of the CAC control is actually means that there will be the information or the document that will be submitted to the Director General of the DFT, and then the Director General of the DFT will assess and verify whether there is a risk or not. If there is a risk, the DFT Director General will issue the catch-all control measure, which include also the prohibition of the export, re-export, the prohibition of transit, transshipment, or the transfer of technology outside of Thailand. However, up to date, there is no clear rules or guidelines regarding the transfer of technology outside of Thailand, that how DFT will control on this part. And if the exporter would like to challenge on this point, then the exporter has to submit a letter to the Director General of the DFT to re-examine that there should be no risk on this point, that the product will relate to the proliferation of the WMD. Then there will be an appeal to the Minister of Commerce as well. And then next one is that about the ICP. The ICP is actually the internal control program or internal compliance program for the business operator that would like to be proactive on the WMD issues. It means that the ICP shall consist of the following system. First is the system regarding responsibility and delegation of management duty. And second is the system regarding usage and end user verification. Third is the system regarding the internal training. Fourth, the system regarding information and document management. Fifth, the system regarding system check and improvement. And sixth is the system regarding reporting. And there will be the certification for the ICP business operator in 3 levels. Good, which means that 2 or more systems of the ICP meets the criteria. Very good. It means that 4 or more systems of the ICP meet the criteria. And complete, it means that all 6 systems of the ICP meet the criteria. And any business operator who wishes to have its ICP certified by the FT can register at the eThailand's control of weapons of mass destruction related items, or ETCWMD system provided by the DFT. And before registration on that part, the business operator has to have a representative from the business operator to attend the training on the ICP in-house training program held by the DFT. And we understand that the DFT is now opening for the registration of the ICP in-house training program at this stage. And it will be held at the beginning of next month. Then it's about the custom audit trend in Thailand. So I would like to hand over back to Khun Panya to
All right.
clarify on this part.
Thank you, Khun Kirati. So we would like to cover a bit about the customs audit in Thailand. Custom audit in Thailand has been very aggressive in the past, and then now, after the COVID situation, we expect that the officer will be more proactive in the area again. So we would like to touch upon this a little bit so that you can get the heads up what is really going on and what would be the trends for the customs audit. Right? For the background, we used November 17 as the cutoff date. That was when the new Customs Act was implemented. So if you live in Thailand long enough, over that period of time, prior to November 17, and then you deal with the Customs Department, you would have perception that they were very, very aggressive. Many of the company has got investigated, has got criminal charge, and paid a very high amount of the penalty to the Customs Department. And then, the law was implemented in 2017, more transparency, more disciplinary, measures to the customs. Then Customs Department, calmed down a little bit after that time. So after 2017, we do not have seen many big cases, aggressive investigation. Customs Department rather have the post audit in the very similar manner as the Revenue Department. So they send the letters of invitation to the companies, ask the company to prepare the documents, right? So that was the situation. Now, up until year 2020, almost 2 years ago, there was the change again because the new director put in place. They start to investigate the company again. Even it's less than prior to 2017, but we have seen more of the aggressiveness of the Thai customs after the year 2020. And then we have the COVID situations, very fluctuating, right? When the COVID comes to the severe level, then most of the officers are required to work from home. Then over the past few months, starting from September last year, then we do not have seen a lot of audits again because the officer work from home. Then this time the Customs Department has come back to the office. At least they come back 3 days a week. Some of the officers at the high ranking comes every day. They started to make the audit at the premises of the companies again. So this is coming of the new situation that we expect that the custom audit will become more popular, and then will be more and more again, because the custom officers would be required to go out and have the audit at the premises 3 days a week as the policy. So we will see this one. Again, the Post-Audit Bureau of the Customs Department now just announced the Voluntary Disclosure Program. This time they announced 5 years program, which never happened in the past. In the past, they only have like 1 year, 2 years at most, but now they announced it to be 5 years. So this program will be ending, at 2025, 2026. Then any company who, have found that they have done something wrong can walk to the Customs Department and volunteer to pay tax without the penalty. Also, at this period of time, Customs Department, grant the reduction of the surcharge, which is the interest in kind. So there are a lot of benefits given by the Customs Department this time to encourage the company that to conduct the health check regularly. If they found something, then they can walk to the customs and then do the voluntary disclosure. So customs seems to be more professional this time, more calm, and have a lot of voluntary disclosure benefits for the company to just volunteer to pay. So the situation is getting better again because they are required to visit the companies 3 times a week, 3 days a week. So there will be aggressive audit going on just to balance this out. We also have seen many of the officers at the port becoming very proactive. So they ask a lot of questions. So stay tuned and try to get in touch with the shipping agents all the time, because when the customs officer asks the question at the port, it would mean something. So do not ignore that question, because it might turn to be formal audit very soon if we ignore those kind of questions. On the next page, we try to list the top 5 of the customs issues that have been raised over the audits and even over the time of importation by the port officers. So we have number 1 is the classification issues. Number 2 is the use of the privilege like BOI. Number three is the import-export compliance, import license, import certifications, those kind of things. Number four is the utilization of the FTAs. And number five is the customs valuation. Customs seems to be less proactive on this, but recently we have seen some of the hotspot issues like transfer pricing adjustment as well as the royalty issue. So Kun Kirati will go into updates on each of the items here and the interesting cases that we are handling at the time. Kun Kirati.
Thank you, Kun Panya. So as Kun Panya just mentioned earlier, that number 5, the custom audit trend is the custom valuation issue that we see in this is coming issue due to the fact that the Revenue Department just implemented the transfer pricing policy and regulations in Thailand. So the first issue that the custom officer will challenge is the transfer pricing document and policy, which are related to the custom value of the products, including the transfer pricing adjustment, whether that will affect the increase or decrease of the price of the products. And also there is another portion that the custom officer usually audited, which is the production loyalty and also other like expenses that actually transfer outside of Thailand, including the commission issue as well. So for the loyalty issues, actually according to the GATT valuation and also the Custom Act, the loyalty which should be included and added into the custom value of the products must be related to the products and also must be the condition of the sale. However, the Thailand custom would like to challenge many kind of production loyalty, which is actually loyalty paid for the production or manufacturing process of the finished products in Thailand. And then we pay that part of the production process, patent or information like technical know-how and technical information back to the owner of the IP rights. And then Thai custom would like to challenge on that part as well. So the next one is the custom audit trends, number 4, which is the utilization of the duty preferential treatment under the FTA. Because there are actually unclear practice when 2 rules under the FTA are applied. For example, the back-to-back issue and also the third country invoicing issue. In the past, according to the Artica FTA, so there is no clear rule that the back-to-back and also the third country invoicing can be used together or not. And Thailand interpret it conservatively that if the FTA allowed to do so, the FTA must be explicitly clear on that point that these 2 rules can be used together. However, on the other part of the ASEANs, like Singapore or Malaysia, these 2 countries try to be proactively interpret on this FTA that if there is no prohibition on the use of together rules, then that means that FTA allows the importer can utilize on that privilege. Then it must be quite careful on that part as well. Also, same as the compliance during the transition of new rules. When there is the new rules, for example, the third country invoicing under the Hong Kong ASEAN FTA, there is no clear guidelines on whether the third party invoicing can involve more than 3 parties in the transaction. Then the Thailand will provide a strict interpretation on this part as well, that it must be only 3 parties involved in the transaction. Then it should be careful on that part and to consult with the custom department on whether they will allow the importer to be beneficial according to the FTA or not. So the next one, number 3, is the import and export requirements. So we have experience in many cases where the custom department by the audit department actually challenge the importer on the classification of the products. And then the new custom tariff code that read by the custom officer actually subject to the import requirements, whether it be the registration, just mere registration with the authority, or the import certificate or import license from the authority, then the importer will be subject to the import requirements also. And also the list of products control that are available on the website of the Thai custom may be sometimes not reliable, because it not like all the product control available on the website of the Thai custom. In the recent case, we see that the products, which is fish oil, that actually classified under the HS code, and then the HS code linked to the import requirements of the Thai, and under the website of the Thai custom, that it must be subject to the import requirements from the FDA or the Food and Drug Administration of Thailand. But then at the same time, the products must be actually subject to the import requirements from the Department of Fishery as well as the product from the marine and sea animals. Then it is quite be careful that the information shown on the website of the custom may not be reliable. So you have to check the composition of the products and the nature and characteristic of the product as well, with the relevant authority, that there will be no further or additional import requirements required at the time of importation. And number 2 is the utilization of custom privilege, such as custom free zone, bonded warehouse, and BOI. So this is the issue that the custom officer frequently audited against the business operator, including the incompliance with custom formalities. For example, there are many types of custom form related to the business operation in a custom free zone or the IEAT free trade zone. And it means that if the business operator fails to comply with the specific custom form, there might be create the custom formalities offense, or ultimately it might challenge that the importer will not be entitled to the duty exemption or the reduction privilege. And the next one is exercising discretion on custom privilege claim. And for example, in a custom free zone, there is a regulation that the products can be subject to 0% import duty when moving the products out of the custom free zone for domestic consumption. And that the importer must prove about the local content ratio. And many times that we usually face that the relevant authority, for example, the police or the Department of Special Litigation, will challenge on the local content calculation of the products, whether or not it will meet the criteria that will make the importer be beneficial for the duty exemption or reduction privilege when using the utilization of the custom privilege in the custom free zone. And the number 1 issue is the custom tariff classification of the import duties. And nowadays there are many challenges from the custom officer in various products. But what we face now is, first is the interpretation of GRI rules through A. It means that at the time of importation, the product is not incomplete, or it is unassembled or disassembled. But then the custom officer tried to challenge that the incomplete products or the unfinished products or the unassembled products or disassembled products are actually considered as the complete products according to the GRI rules of the custom department. For example, the parts for the automotive parts that imported in many parts, like in high percentage of the products compared to the finished products. Then compared to the parts that used for the finished vehicle or motor vehicle. Then if that the ratio is quite high, the Thai custom try to challenge that. All these parts must be actually considered as a motor vehicle or the CKD of the motor vehicle at the time of importation. And the next one is that the tendency of classifying in higher rate of the SS code from the Thai custom. It means that there might be two relevant SS code for the products, particularly the new products or the high technology products that there is no clear explanatory note or there is no clear information on the products with respect to the clarification on the SS code. Then the Thai custom department will, of course, try to challenge that the product is actually subject to the higher duty rate SS code instead of the lower rate. So that's all the custom audit trends in Thailand. So now we will move on to the custom cases and practice and case studies. So for the first case study, it is about one importer actually import safety glass for assembling in motor vehicle. And this importer actually declared the products under SS code 7007.21, of which the import duty is at 10%. And also must comply with the TISI import requirements as well. Then in 2018, the World Customs Organization issued its classification decision, which actually similar to the products imported by this importer, that the WCO will actually reference the import with frames and other features of the product. If there is frame and other features together with the glass import, the safety glass imported into Thailand, then it should be classified under SS code of 8708.29, which is considered as the automotive parts, and the import duty is quite high at 30%. And based on the national single window system, the safety guard under SS code, only the safety guard under the SS code 7007.21 is subject to import requirements of TISI. Then the issue is that should the WCO decision be applied as classification precedent retroactively on the past import for this importer as well? And the answer is that the Customs Department tried to challenge that this WCO decision will make clear that it will be applied to all the imports of safety glass imported by this importer. However, what if the importer has a custom ruling regarding the HS code 7007 for the products in the past? Then the Customs Department in practice will accept that it is actually the mistake of the Thai custom rule classifying the products under 7007. Then it will not have the retroactive effect on the transaction in the past, then it will be going forward transaction only. And the third issue is whether the import requirements under TISI are still applied to the products when the products are actually classified under the new HS code of 8708 as the automotive parts. Then the TSI respond that TSI does not regulate on the HS code perspective. They will see the nature and character of the products. If the product is actually considered as the safety class, same as the SS code 7007, then it will be subject to the import requirements of the TII as well. So from this case study, whether Khun Panya has anything to add on?
Okay, I would say that this case is quite a bad luck for the importers in Thailand, because the decision came from World Customs Organization, and they took a lot of long time to consider the matter. And in some countries, you might know that classification and duty rate for the vehicle parts is less than the normal part, so which is contradictory to Thailand, right? Because automotive parts in Thailand will be subject to 30%, but the normal part will be 10%, 5%, 0%. So there are some countries that push it to be automotive parts because they would like to have less duty. So very unfortunate for the Thai importers. Most importantly, when the WCO launched the decision formally like this, Thai customs will have 100% intake this information and conduct the audit against the companies. So all the companies importing these products will be subject to the audits at the same time. And it's very difficult to defend because the precedent case comes from World Customs Organization. Some companies were very lucky. They got the advance ruling from the Thai customs. So Thai customs accept that. Some companies no, because they might rely on someone else's ruling, or they never been aware of this issue at all. So Thai customs for sure will try to claw back the duty. So there are many pending cases on this one. Just to be careful when there's the new decision coming out. If it is related to the products that we imported, just find a way and be prepared to get the audits from the customs. So that's what we got from this case study, Khun Kirti.
Thank you, Khun Panya. So we move on to the case study number 2. This case is actually an importer import essential oils in retail packaging. And then these essential oils have multiple applications, including skin application, consumption, and room deodorizing. Then it will be subject to relevant SS code. The first one is 3301, which is an essential oil other than those of citrus fruit, and the import duty is 5%. And the second one is a preparation for perfuming or deodorizing rooms, including odoriferous preparation used during religious rites under SS code 3307, and the import duty is actually at 20%. So the custom issue is that, first, what if the product has multiple application? Then, according to the Thai custom laws and the practice of the Thai custom department, the custom officers will try to interpret that this product has to be one main major application, and it can be classified under that major application. And the application in this case may be actually relied on the relevant certificate. For example, the certificate of the Food and Drug Administration, if the product is actually used for the daily consumptions. And then, what if some of the products application are required for registration with the authority, and some are not? As earlier mentioned, that it might be related to the registration of the relevant authority. But for example, if it is the product that are subject to registration with the FDA in Thailand, FDA in Thailand does not accept the the multiple applications per se, then it means that the importer must actually apply for one single application of the product itself. Then that application can be actually affect the tariff classification of the custom department as well. As for the precedent of this case, the Thai custom used to interpret that if the product is actually with the general use of the application, then the product tends to be classified under the SS code 3307 and the import duty is higher at 20%. But if the product is actually used for like the skin application, or it can consume for the daily consumption, then the product is lower at 5% as it is registered with the FTA as the food. Then that is the case study number 2. So could you have any insights on this case?
For this case, we raised because we'd like to bring attention when the two divisions of the company independently worked, but result in a very bad shape. Division handling customs matter request for the advance ruling with the customs, right? Another division handle the FDA license with the FDA authorities. And then eventually Thai customs use the information that the division registered with the FDA to attack the company, saying that because the company register a product with the FDA on this category, so that will be basis to determine the HS code as well. Even when the application of the products can be very broad, but when the company register with the authorities like FDA, it could be used to harm the company this way. We also handle many cases under the similar situation when the regulatory division try to register the product with the authorities like BOI, with the Ministry of Industries, with the FDA, with other authorities. And then when we handle the customs work, those kind of information is used for a determination of the customs issue like tariff code or valuation, and the company will be very difficult to defend their position because we submit such information to the authorities already. So this is the sense that the company internally may need more collaboration between divisions. So that's the sense of this case study. Yeah.
Thank you. So for the case study number 3, and this is the last case. So this case is about the importer obtain actually all the necessary documents for claiming the duty reduction privilege under Section 12 of the Custom Tariff Decree, and according to the notification of the Ministry of Finance or the MOF notification, and submit all required documents to the custom at the time of import, formalities and clearance process. And the goods themselves actually meet the condition and criteria for duty privilege. However, the importer had not obtained an approval from the custom department before the import of the goods. And this condition actually indicated in the custom notification only, not the MOF notification. And then the matter was under the consideration of the Custom Appeal Committee and the Revenue Board of Appeal more than 270 days from the complete appeal application. Then the issue is whether the importer can utilize the privilege if there is no approval from the Custom Department before the importation of the goods. Then this case, the Supreme Court of Thailand has long-standing interpret that the condition that will grant the importer for the rights to duty reduction or exemption must be the MOF notification. So the condition or additional criteria stipulated in the custom notification will be considered only as the custom formalities only, and the failure to comply with the custom formalities does not validate the right to duty reduction or exemption privilege. Then another question is whether the importer can file a lawsuit against the relevant authorities, which is the Revenue Department and the Custom Department. Straightforward. So it will be two cases here. For the first case, the importer can actually file a lawsuit against the Custom Department straight away, because the Custom Act actually allows the importer to bring the case to the court. If the appeal cannot be rendered its decision by 270 days at maximum. However, regarding the Revenue Department, the Revenue Code does not grant any rights to the importer to have such privilege. Then the importer cannot sue the Revenue Department at this stage. However, there will be another implication on this part as well, that there is, if it will be in the court and it is the court rule that the privilege can be claimable if no approval from the Custom Department at the time of importation, then it will impact, legally impact the VAT base, as the import duty is actually the basis for the calculation of the VAT as well. And our case study 3 is actually based on the previous MOF notification, because we would like to note that now the approval process is now moved to the MOF notification at this stage. So, Khun Panya, have anything to add on this?
Yes, for this case, I think the most important key point is that all the privilege that Customs Department gave for importation always comes with the condition, and Thai Custom interpret that very conservatively. So if the company has any questions or doubtful whether we comply with the customs, so we better check it in advance, because after the long use of the privilege, when customs picked up, then the consequence can be very high. So that's the sense what we try to raise the case for your updates for the moment. And we have handled many cases like this, both in the audit level and in the litigation levels. So be careful on this one. So just to wrap up what we try to present on the customs audit. Most recently, custom audit seems to be less proactive, less aggressive, but they are coming back very quickly after the COVID situation. And the custom audit will for sure happening once every 3 years. If the company has not been audited for quite some time, then that would be the first target of the Customs Department. Just for the preparation and management of the customs audit, first thing first, I think we need to determine when the company is audited, what would be the type of audits, if they are audit at the port, or audit by the Post-Audit Bureau, or by the Investigation Bureau, or even by the Department of Special Investigation. When we can determine the type of audits, then we can work on the strategy how to handle that. Most importantly, when the custom audit comes in, please set up the working team in the company themselves, between the divisions like accounting division, finance, supply chain, operation, business, just to walk through what we have done in the past and be prepared for the audits. Next thing is to handle the audit proactively. Don't let the customs officer feeling that we are not very cooperative. Otherwise, they will be more aggressive. But we have to be more conservative. Don't let more information to the officer more than is necessary, because sometimes the officer doesn't know any points or doesn't have any target, but they know it because the company feed the information to them. Last but not least, if the company has the customs manual or crisis management manual or dawn rate management, then we better use that at that time. And then afterwards, you can determine whether the consultant is necessary. Sometimes yes, sometimes no. Sometimes you can just engage consultant to help you manage the audit, and you don't need to let them front with the custom officer. So sometimes that's the good strategy. So with that, I would like to end the presentation for today. For the Q&A questions, we have got some questions. However, we are running out of time, so we will only do 1 or 2 questions. And for the rest of the questions, then we will respond to you by email afterwards, right? So, Kun Kirti, can you?
Sure. For the first question, we would like to know if there is like the TP adjustment for the transfer pricing adjustment retroactively, how to approach the custom department.
All right. So for the TP adjustment is now the high season, because now it's just the end of the fiscal year at December, or some company will end fiscal year by the end of this month, right? So it's very high season for the TP adjustment. And if the adjustment impact the customs duty, then, conceptually, we need to approach the customs and do voluntary disclosure. Even if it's not impact the custom duty, but it will impact the VAT because the price of the goods is changed. So we probably need to think about to approach the customs. Not every case that we recommend to approach the customs. In some cases, if the company, retain the position that, the price is changed, but there's no duty implication, and there are, too many of the import declaration forms to be handled. Sometimes the company will just notify the customs without having to change the custom import declaration form. That would be a more proactive way to comply with the law. But sometimes Thai custom is not willing to change anything in import declaration form when it contains too many of them, right? So that's the practical approach. So for sure, TP will impact custom formalities, but whether the company will have to approach the customs or use the wait and see, it would depend on the situation of the company.
All right, and for the next question is what products custom potentially will be auditing, and whether there is like major cases regarding computer products imported into Thailand.
IT product has been put on the spot as always, because it might be subject to 0%. It can go to 10 or 20% if it is the entertainment products, right? But now we only have the new HS classification just implemented at the beginning of this year. Then some of the categories of the technology product is changed to be clear. Some change to be less clear, right? So be mindful on that. So that is the main focus of the customs, in addition to the automotive parts, which are always on focus. Just if you are not clear or not very sure, do not rely on shipping agent, or do not rely on shipping agent when they verbally talk to the customs. So we might need more measures on that. For example, to seek the formal rulings prior to importation, or even during the importation, some products has been imported for a long time, then you can get the custom classification rulings as well. But think about the implication before submission of the rulings, right? So that's the overview of the situation for now, right? So I think we are running out of time. We still have some questions. We will respond later. So I will get back to Diego to do our closing and wrap up for this session. Thank you very much.
Thank you very much. Please join me in thanking our speakers, Kun Panya and Kun Kelati, for an excellent discussion on Thailand updates and developments. On behalf of Baker McKenzie and the IMT group, thank you for joining today's webinar. We hope that you found this session informative and relevant for your organization's operations. For more information, or if you'd like to discuss further, please do reach out to me, Panya or Kelati. As a reminder, this is a part of our Asia Pacific IMT webinar series, and in upcoming sessions, we will also hear about the developments in Malaysia, Indonesia, China, and the Philippines. So we would appreciate your feedback on today's session through a short survey that will pop up on your screen after this session. We look forward to having you at our next webinar. Goodbye for now and have a great rest of the day ahead. Thank you very much and bye-bye.